So we've received a few queries from people that have been furloughed and are facing redundancy. Essentially, they want to know their rights. And is there anything in particular that you would like to comment on about this situation?
Yeah, I'll say two things. One is about the process and one is about pay. So being on furlough, you're not supposed to be doing any work, right? That's part of how the furlough scheme originally was set up. But what that doesn't mean, and obviously that's shifting now as we move into the second phase where you are able to do some work, if I recall correctly, not 100%. I'd need to double check that. But effectively, the presumption is that you're not doing work. That's the whole purpose of being furloughed. That doesn't give your employer free rein to just do a consultation behind your back or only involving the employees who are still at work. If you're at risk of redundancy, especially if there's an at-risk group of 20 to 100 or more people, then there's a legal requirement for your employer to do that specific redundancy process that I talked about. Feels like a long time ago now, but right at the start. And you can bring a claim if they do not do that. What has been very clear in both the government announcements and the legislation that we've had, and it's a bit confusing because all of the furlough legislation has been done by the Treasury through Treasury directions, quite often at very short notice. But I'm going to talk about something in a minute specifically that's come from BAYS, from the business ministry. But wherever it's come from, the government's been very clear that the furlough does not affect your rights in any way other than the right to be provided with work to the extent that that's part of your contract. So it doesn't absolve the employer of any of those requirements about a redundancy process that we talked about. It doesn't mean that doesn't get them out of paying the redundancy payment. That's the first thing. So redundancy payment, again, I mean, we try not to blame the Treasury too much for this because they're doing a lot of work at short notice and they're making things up kind of as they go along because they have to. But one of the things that wasn't clear after they announced the furlough scheme was going to wind down is how redundancy pay would interact. Because as I said earlier, redundancy pay normally, if you don't have a contractual rate, it's based on your last 12 weeks. And if you do have a contractual rate, it's based on your contractual salary. Now, obviously, during the period of furlough, your salary was initially reduced to 80%, and and how that 80% is worked out depends on what you were doing at work in the run up to your furlough. And as I said earlier, redundancy pay is normally calculated on your pay at the point at which your dismissal takes effect. Furlough is there are specific regulations that were brought out, I think, in August. I know it was announced on the last day of July, that are in effect, that effectively say if you're made redundant whilst on furlough, your redundancy pay should be calculated on the basis of your pre-furlough pay. So it shouldn't be calculated on the basis of 80% of your contractual salary. It should be whatever you're being paid before furlough. Now, there is one complication to that I think maybe hasn't been thought about too much, but I know someone had raised it, which is what if you come back from furlough and your hours are changed? Now, given that nothing else I have to read the regulations to be 100% sure about this, or reread them, I should say, but if you agree to a contractual change, either hours or pay, I mean, obviously hours will normally affect pay, but if you agree to have your salary reduced and then they bring in a redundancy process, then after you come back from furlough, even if the changes were made whilst you were on furlough, I don't see how you'd be able to say you should get your 100% rate from before furlough. It will be whatever your 100% rate is at the time you get dismissed. I think it's quite unlikely for that to happen. Certainly would. I mean, I've heard of one example of someone being changed whilst on furlough. I mean, there's a contractual argument about whether or not that's even allowable without your consent, because most contracts don't have a right to unilaterally vary a contract. And if an employer does that without your consent, and there's no part of the contract that says they're allowed to do that, then that's potentially a breach of contract, and you're potentially entitled to take that as you're entitled to bring a breach of contract claim. The downside for you there is that a breach of contract claim effectively requires the contract to be an end. So it requires your employment to cease. So that's not much of a solution for you if you're wanting to avoid being made redundant in the first place. But like I said, the key consequence of furlough is you might find that your employer has found they can get along without you or with less of you. But there is no, although the pay issue has thankfully been resolved, there's no furlough discrimination. So there's no automatic right to bring a claim for unfair dismissal or for your dismissal found to be unfair because they selected the people that were on furlough for redundancy and not the people that were back at work or the people that never went off work. And I think I'm fairly safe in saying that it's unlikely, providing the rest of the process is fair, that would make an otherwise fair dismissal unfair. And the reason I think that is that the way that the furlough scheme operates is that the employer has almost complete discretion on who to put on furlough and who not to put on furlough. And in fact, it could have put none of its employees on furlough and made everyone redundant in March and April if it chose to do that. There's no requirement to put people on furlough. So I don't see normally if they're choosing between who to put on furlough, and some employers will have had a rotation policy to try and keep it fair, but there's no requirement to fairly select who goes on furlough unless it's discriminatory. So normally the employer probably would have made an assessment about who it wanted to keep in the office or at work and who it wanted to furlough, and that would probably have been along the same kind of criteria as it would decide as who to select for redundancy. Who's the best at their job, who can get to, maybe for furlough it might have been who can get to the office or the place of work easiest. So we'll furlough the people who would live further away so that they're not at risk as much. But broadly speaking, the employers probably, if you're on furlough and other people aren't on furlough and you do the same job, I think you can reasonably expect that you are slightly more at risk of being selected for redundancy than them, just because that's probably why you were picked to go on furlough in the first place.
It makes sense.
Does that make sense?
It does.
So furlough and redundancy might interact in that way, where not everyone is on furlough. And the other thing is that obviously furlough scheme is set to come to an end at the end of October. That doesn't mean that you have to stay on furlough until October just because the sum of your wages can be recouped from the government through it's not technically called the furlough scheme, but what we will call the furlough scheme. So it's perfectly legitimate for the employer to say, well, we know in December we're going to get rid of 10 people. And furlough the access to the scheme is the administrative payroll process that needs to be done. And I don't know how difficult it is for payroll to do it because I'm not in payroll. But certainly before the scheme actually started, people were being furloughed, and the government was encouraging people to be furloughed before the scheme had even started, so before people even knew 100% they would get reimbursed. And so it's perfectly legitimate for the employer to say, well, look, we don't need to we could continue the furlough scheme until October, but actually it's less work for us if we make the redundancies now. We know there's been the diminution in work, or we need less people to do this work, or we're closing down that particular store. Why wait until October, not get everything done in September? And ostensibly there's no reason why they can do that. One of the big problems we, as advisors, we had early on when the furlough scheme first came into being was people saying, oh, the employer's chosen not to furlough me. Well, it's too bad. I mean, there's nothing you can do about it. And it's the same with that, you can't require your employer to carry on the furlough scheme if they've decided to make redundancies. I mean, they're perfectly entitled to do that. So those are the obvious things. I don't know if you've got anything specific you were thinking of.
No, I mean, I guess it's just an understanding of how all of this interacts with what we're dealing with now. And I think you quite helpfully pointed us in the right direction. So I believe the final question is, if an individual needs to represent themselves through the redundancy process at the tribunal, are there any helpful guides or information that they can rely on in order to do that? Hello? Hello? Oh, Dave, I think we lost you for a moment.
I didn't hear a word you just said. I'm sorry. The screen froze and I lost audio.
I'll repeat that. So the question is, if an individual has to represent themselves, we know this is something that's happening more and more due to lack of, especially free representation. What can that individual rely on in terms of guides or resources to help them through that process?
Yeah. So for the employment tribunal, and almost all claims that relate to redundancy brought in the employment tribunal, very occasionally you might bring a breach of contract claim in the county court, but just don't do that unless you've been advised to do that. So, I mean, the industrial tribunals as they were when they originally set up were supposedly set up so that you wouldn't need a lawyer. But I think that anybody that's been through that process definitely feels they would have benefited from having a lawyer. The first thing to say is don't panic too much if you can't get assistance, because as much as a court process is able to be done without a lawyer, I'd say the employment tribunal was pretty good on that front. And good judges in particular, and not all judges are good judges, but good judges are pretty activist in assisting. And in fact, one of the things that's important to remember about employment tribunal judges specifically is that although they are obviously neutral, they have very wide case management powers, and they're entitled to get involved in the case in a way that you might not otherwise expect a judge to do. So, for example, they might gently give you a very strong hint that perhaps one of your claims should be withdrawn, or they can amend claims of their own motion. So they might decide that, oh, actually, you brought a claim here, you haven't labelled it correctly. It's actually you brought a claim for this, but actually it's this, and I'm going to allow you to amend that claim, and I'm going to tell you how to do that. I mean, depends how much time the judge has, but leaving that aside, and the other benefit I should say of the employment tribunal is it's kind of expected that the employers who will normally be represented, we hope by solicitor. Sometimes there are some employment consultancy businesses that represent that are not as good and not as helpful. But generally, someone like you and me who's been trained, who's up against a litigant in person, first of all, they kind of have an ethical obligation to try and help you out in terms of when an order is given that you do a thing, maybe helping you understand that you're not doing that thing. So you're not making disclosure in the same way, or you really shouldn't be making your own bundle. That there should be one joint bundle, and please don't make your own bundle. All it would do is irritate the judge and make my life harder and your life harder. But also that making documents, most of the documents, like the bundle of evidence, for example, that the tribunal will look at, is on the other side.
Sure.
It's normally expected the respondent to do that and kind of bear the cost of doing that. So that's the first thing, is if you can't do any of the things that I'm about to talk about, don't panic. It's doable. I have taught people who think they're very ill-educated and not very clever to cross-examine effectively in about half an hour. You can do it. It's doable. And no one will know your case better than you do anyway. So, there's that advantage to it, I suppose. It's more stressful. There's no doubt about it. It's more stressful, and there will be technical terms we won't know. So what you're looking for, there's two types of way out of that. One is advice and one is representation. And one is easier to get than the other. So unfortunately, for as long as I've been involved in doing employment law advice, which is 2009, employment law has been out of scope for legal aid. So there really isn't legal aid for employment law. So I do get people who think there is. It's just not in scope. There is the civil legal advice, which is a telephone helpline, which will do some telephone advice for discrimination claims, I think only. But that's really it in terms of what legal aid, what is technically legal aid.
Mm-hmm.
Pro bono assistance is possible. So if you had an amazingly groundbreakingly good legal case that some very high profile barrister or solicitor's firm would really want to take on because it might make new law or something, then yes, you might be able to get someone to represent you, what we call pro bono, for free. That's pretty unlikely. Although with the coronavirus, there is law to be made, I think. So we don't know, but that's pretty unlikely. Normally, you would see it would get picked up at a higher level. So if you went to tribunal and lost, but there was an appeal, it might get picked up for free in that way. So you're really looking at two basic sources of free representation. One very helpful is called the free representation unit, which does take some self-referrals, but I think they have to be pretty basic. So most of the time you have to be referred through an advice agency like us or through a local citizen's advice, who will normally be quite happy to do it because it involves, then you don't need their help. And so they can give help to someone else who isn't in tribunal yet. The problem with FRU is that you have to have brought your claim already. And when you submit and that's probably the only problem with FRU, they're a great organisation. And I should say, declare an interest that I technically am still a volunteer there and have been a volunteer there in the past. But they only take claims that are already in tribunal. So you have to have a claim form, what's called the ET1, the response form from the other side, which is called the ET3, and you have to know your hearing date. Now, it doesn't necessarily have to be your final hearing date, it could be your first hearing date, but you have to have a hearing date, and that has to be no more than 2 weeks. I think it's 2 weeks in the future for them, and 3 weeks for the other organisation we'll talk about. But it's not very long, effectively. Luckily, if you just bring a standard redundancy unfair dismissal case, I think it's still the case, so again, I'm not as in touch with the tribunal service as I used to be, but certainly up until the virus, they were given hearing dates pretty much before you got a response. So you should have a good idea of when your hearing date's going to be enough in advance. But how the FRU process works, and it's a bit different now that they're not in the office, but I'll describe it this way because I think it makes it easy to understand. Basically, on the wall of the FRU office, there is a shelf with a load of folders in. When they get your case, that case goes in one of those folders and it goes on a database. And when I, as a volunteer, one of the other volunteers, looks at the database, they go, oh, I'm free on that day. Oh, I fancy a bit of discrimination. I'll go and have a look. And they go into the office or they get access to the bundle, they look at it and they go, yes, I think I can do this, or no, I don't fancy this for some reason. There is no process of allocating cases to volunteers, except where Michael, who is I forget what his technical title is, but he's the head of employment effectively. And he will do some cases and he will have an assistant legal officer who will do some cases. Because their main jobs are supervising all the volunteers, they don't take on that many. So very rarely you'll get allocated to someone. And it's basically up to a volunteer to find you. Now, that's very frustrating for claimants because basically means it's very much a don't call us, we'll call you policy. And you might never hear from them. And I think you're instructed, if you haven't heard from them within 7 days of your hearing, to presume that you're not going to be helped. So they're a great service when you can get someone. They grade their cases. So not all of the volunteers are lawyers, are qualified lawyers. Some of them are people like me who kind of are trained but not in practice. And others are people who have still got students. But they've all done a training course and they are given they won't be allowed to take on a case that's too complicated for them. So the simpler your case, the more volunteers there are that are going to be able to do it, and so the more likely you are to get it. And the shorter your case, the more likely you are. Because if you've got a 3-day case, it's going to be a complex case, it's going to be a discrimination case, and you're looking for someone who's very experienced, who's got 3 full days of their time that they're willing to do for free, notwithstanding all the prep work, at the exact 3 days when you need them to be free. It's pretty tricky. I mean, you'll know that I haven't been in practice, so that's difficult. So FRU's great if you get them, but I don't know what the percentage is of people who are referred there who then get picked up. My suspicion is it's not high. Don't despair if you don't get picked up straight away. I have picked up simple cases a week before hearing, but normally that's to convince the person to settle and withdraw rather than because I think they've got a super strong case. So that can happen, but realistically, if it's a month out, you're probably on your own. The other organisation is called Advocate. It's what used to be called the Bar Pro Bono Unit, which I think is still based at City University, but I don't know. They will take any kind of legal claim, but we're talking about employment here, and they'll take it at any stage. And they do advice, they do representation in court, they do some drafting. They're very specific about the types of drafting they will and won't do, and that's all on their website. And you can self-refer to them, which is the advantage. So you don't need to come to us and wait for me to find time in my schedule to do a referral form, or Citizens Advice to give you a slot to do a referral. So you can self-refer. The only problem with Advocate, well, there's two problems with Advocate. One is that they won't take your case on from start to finish. So they won't take it on, bring the claim for you, represent you in court. If they represent you in court, it will be for a hearing. So they might do the preliminary hearing for you, or they might do the final hearing for you. They're unlikely to do both, and they won't continue to represent you throughout the process. And I think they're quite reluctant to draft claim forms as well. But they might look at a witness statement for you, or draft a particular application for you. It varies because their instructions are quite broad, so they cover all the different scenarios. And the other thing is that if you are in a relatively good job, they probably won't help you, because they do have, and it's very vague about what it is. And I think that's to give them a bit of leeway to take on what they think are meritorious cases. But they generally say if you wouldn't be eligible for legal aid, if legal aid existed in your area, that they don't guarantee that they'll assist. I mean, they never guarantee that they'll assist, but they're less likely to assist. So if you're earning £2,000 a month, or you get made redundant and you get another job where you're clearing £2,000 or £3,000 a month, they're a lot less likely to help you than if you're on universal credit, or if you're earning a small income, or you have very low disposable income. So you might be earning good money, but you might have 5 or 6 children, or an expensive mortgage. So applying for Advocate is a bit more personal because it involves disclosing quite a bit of financial information about your incomings and your outgoings, and that might not be for you. But that's all on their website, what they do and how they apply. In terms of other sources, obviously there are places. So Citizens Advice does have some caseworkers. So you'll know we have volunteers, I won't name them, but we have volunteers who do casework at Citizens Advice in various areas. They're pretty limited, and obviously you have to live or work in the area for that Citizens Advice normally. And there are obviously the options of, I mean, obviously you can pay for a lawyer, or you could get a lawyer on what we call a conditional fee agreement, which is what most people know to be a no-win, no-fee agreement, which we know is a bit more complicated than that. I would be very careful about doing that. I would say two things about that. First, be very careful, make sure you get a client care letter, make sure you understand what the document says, because particularly the document will specify on what circumstances you can withdraw. And we have had a client, not in an employment context, but where he was on no-win, no-fee, decided he didn't want to stress any more of the claim, decided to withdraw, and then they said that was in breach of the agreement, and they tried to pursue him for their costs, effectively. And it took about a year to sort that out and get them to go away. And there was no guarantee that that would be successful because he was technically in breach of the agreement. So be very careful about that. If you go to 10, I would always say go to like 5 or 10 different ones. And you can find them on the Law Society website, look up for employment, and look for people who've got preferably the Lextel mark or one of the other quality marks. But generally, if you go to 10 employment solicitors and they all say we're not going to do this on a conditional fee agreement, that's probably a good indication that there's something about your claim that is not good, that's not likely to succeed, because obviously they only take on claims that they're very confident will succeed, because if they don't succeed, they don't get anything. So that's always an option. And of course, if you've got money, there's always the option of paying for a solicitor. And in fact, I was talking to a colleague yesterday about a different area of law, but I was saying paying for a solicitor doesn't mean paying for a solicitor for the next 9 months. You could go to the solicitor and say, I'm fine to do the claim on my own, but I really want someone to draft it. So will you know, and you might have, and we've had clients clients do that, come to us with I'm like, wow, you really drafted this claim form well, and they'll say, oh no, I've got a solicitor to do that, but now I've run out of money.
Sure.
So you could get a solicitor maybe just to do the final hearing, and there are some direct access barristers, they tend to cost a bit more. So there are, and a lot of solicitors will do like a free, like 15-minute or 30-minute consultation, especially if there's a chance that you'll be giving them some money afterwards. So that's always worth exploring if you've got the means. But obviously, a lot of people won't. I mean, I wouldn't want to pay for a solicitor, and I'm in a lot better position than a lot of people. So that's another option. There are websites about the gov.uk website is good at giving you kind of basic rights-based information, and that's where the employment tribunal form is. There are Citizens Advice website is usually pretty good. We have some resources, of which this will be one. And obviously there are law centres, advice centres, like I said. In terms of online help, there is a website which I think is still going, called etclaims.co.uk, which was run by Naomi Cunningham, who's a very good employment solicitor, and Michael Reed, who I mentioned earlier, who's at the Private Representation Unit. I think that's still going, but even if it's not, a lot of the advice on there is kind of timeless, because it's things like, don't get into a tizzy because this exact document you want in the bundle isn't included, or and the law in a lot of areas for employment law hasn't changed that much in the past couple of years. So that would be the obvious one. And there are books, and obviously we are not Waterstones, we are not trying to sell people books, but there are obviously the practitioner texts, which are very expensive and probably a bit dense. That's not to say anything about the wonderful authors who write Tolley's Employment Law Handbook or Harvey's Industrial Relations or any of that. They were wonderful and they're great texts, but they're probably not for normal people. So there is Legal Action Group generally are good for resources. And Tamara Lewis's book, I forget its title, I think it might be called Employment Law Handbook. It's on Amazon in various editions. Is relatively affordable. I think the last edition was about £40. I mean, it's not cheap, but it's better than obviously £300 for a copy of Tolley's. So that's available, and there is Employment Tribunal Claims, which again is by Naomi Cunningham, and I think Michael Reed might be the other co-author of that. And that deals much more that deals specifically with the tribunal procedure. And both of those books have, which the lawyer aimed books don't have. They have examples of claim forms and examples of what. I mean, we get a lot of people. I don't know how to do a schedule of loss. I don't know what that is, and that's. I mean, for people who don't know, that's what money you want the tribunal to award you. Effectively, there are precedents for that. If you Citizens of Advice website has that, but these books have it all in one place. If you're like me, I like books rather than on a screen. So there are books you can get. And again, if you get last year's edition of Tamara Lewis, it's probably not that much has changed. Certainly, the tribunal procedure hasn't. I mean, the tribunal procedural rules haven't changed since 2014, I think. So you're probably on a fairly safe ground. The one thing those books won't cover, apart from the more recent edition, obviously, is furlough and COVID-related stuff. But those are out there. Yeah. And obviously, if you're in a trade union, early stages, they can be very helpful. They generally won't represent you in tribunal. I know one union at one time had basically needed you to have an 8% chance of success, which always makes me a bit wary, because I don't like people that give percentage terms of success in the first place. But you will find your union support, and this is no bad thing about the unions, they have limited resources. You'll find your union support will drop off the deeper into the process you go. And obviously the union when it's acting collectively, it's not looking out for you individually necessarily. So union reps are great, but if you can access other forms of support, you should probably do that as well. It's never good to have just one source of advice, unless it's me, of course, because I'm that good. But generally speaking, certainly at early stage, you get lots of sources of advice, and don't rely on what your mum, your brother, your nan says, because they want to do redundancy and they know what they're talking about. They might know what they're talking about, but there are lots of resources out there that aren't that hard to find.
Okay, Well, thank you very much, Dave. That was a very detailed explanation of the redundancy process and the topic in general.